Hi, my name is John Griffith. I'm a San Diego divorce and family law attorney located up in Solana Beach. This is one of a series of informative videos aimed at addressing common issues that come up in California divorce and family law cases. You should note that nothing I say is intended to be or should be construed as legal advice. Family law cases are all different. They all have unique sets of facts and circumstances, and you want to address your specific case with an attorney, you can feel free to call my office. I give free consultations, and we'll talk about your particular case. Today I'll be talking about filing for divorce. So you've made the decision to go ahead and file for divorce. You want to end your marriage. You need to know what the first step is and what steps to take after that. The first thing that you need to consider is where to file your petition for dissolution. And a petition for dissolution is the initial filing. It starts a divorce case. And when I say dissolution, I mean divorce. In California, we call divorces dissolutions. It's a dissolving of a marital relationship. So you need to find out where you're going to file the petition. In the state of California, you have to be a resident of the state for at least 6 months prior to filing the petition. So if you've lived in California for at least 6 months, you can file here in California, regardless of where your spouse lives. If your spouse lives in another state, you go ahead and file in California, have your spouse served, and you'll be litigating your case most likely in California. Next thing you need to figure out is which county to file your divorce in. You need to live in the county where you're filing your petition for dissolution for at least 3 months prior to filing the petition for dissolution. So if you've just moved to a new county, you need to decide whether you want to file in the old county that you lived in or wait the 3-month period to file in the county that you live in now. Could make a big difference as far as your relationships in the old county as opposed to your relationships in the new county. Now, once you've decided where to file, you want to go ahead and prepare that petition for dissolution. Like I said, it's the initial document that begins the process. And when you're looking at the petition for dissolution, there's several issues that the court's going to want you to address. You're going to be listing all of the minor children of the marriage. You're going to ask the court for certain orders regarding the custody of the children, spousal support, property division, and probably the most important thing that you're going to address in the petition for dissolution is the date that you want the court to consider to be the date of separation between you and your spouse. And the date of separation often can become a serious issue because the parties may not agree on the date of separation. So it's very important that you talk to an attorney about what California law says with respect to the date of separation before filling out that petition. And I can help you with that. I offer free consultations at my office. I'd be happy to talk with you about your date of separation and help you fill out that petition. Okay, so once you get your petition filled out, you file it at the courthouse, and you have to have your spouse served with the petition for dissolution or the petition for divorce. There's 2 different ways that the law provides service of the petition. The first way is by personal service, and by personal service, I mean someone physically delivering the petition for divorce to your spouse. And if you hire an attorney, attorneys usually have messenger services and courier services that will go ahead and get that done for you. Now, there's another less intrusive method that I prefer when starting a divorce. You can imagine that divorces can kind of get emotional. The second way of serving the petition for dissolution would be by mail. And if you're going to serve the petition for divorce by mail, you want to make sure that you have someone else mail it. You're not allowed to either do personal service or service by mail. And you include what's called a notice of acknowledgement of receipt. And if you're going to do service by mail, you want to make sure that your spouse is willing to sign off that he or she actually received that petition. Sign off on the notice of acknowledgement of receipt. Your spouse will then return that form to you, and you want to make sure that you have your attorney file that notice of acknowledgement of receipt with the court. The court isn't going to proceed with your divorce case until they know that your spouse, now the respondent in the case, has been served either way with a petition for divorce. Once you've served the petition for divorce, you'll be assigned a judge for your case, and your spouse is going to have 30 days to file the response. So you've started your divorce and you're ready to proceed. I hope this video has been helpful to you. If you'd like a free consultation, call my office at Griffith Law. We're located in Solana Beach, California. We'd be happy to speak with you about your case.